Good afternoon, ladies and gentlemen. My name is George Pappas. I'm a former immigration judge and now attorney at law. And today I want to talk about the recent Supreme Court ruling. That ruling was issued on June 25th. The Supreme Court case was Mullen v. Al Otro Lado. And that was a decision where you had a majority vote of 6-3. And here the government decided who can apply for asylum and who could not. Stay tuned as we go into a deeper discussion on this case and why I'm so troubled by it. Stand by. Greetings, friends. Today I want to talk about a recent Supreme Court ruling that was issued just a few days ago. The case that the Supreme Court ruled on was Mullen v. Al Otro Lado, O-T-R-O-L-A-D-O. And that was a ruling that came into a 6-3 majority, with Justice Alito issuing the majority opinion. This is a very troubling case because it seems to violate the 1967 UN Refugee Protocol, which we as a country incorporated into our domestic law in 1980. But in this case, let's call it the Lado case, the court held that the government's metering policy, basically meaning the government can physically turn away migrants at the U.S.-Mexican border, and it requires them to wait in Mexico until there is capacity. Does it violate asylum statutes? It does violate asylum statutes. Writing for the majority, Alito stated that immigrants standing in Mexico have not yet arrived in the United States, quote unquote, and therefore do not have a statutory right to apply for asylum or to be inspected by an immigration officer. Now, this was basically a decision that cleared the way for the government to revive and implement this policy at the southern border. Justice Sonia Sotomayor, joined by Justices Elena Kagan and Justice Brown Jackson, dissented. And here, it was a pretty vehement dissent. The ruling here resulted in a rare exchange between Alito and Sotomayor during the reading of their respective opinions from the bench. So, according to this Lado U.S. Supreme Court ruling and Alito's majority decision or opinion, the government now has a statutory right to keep people away from the United States so they can't apply for asylum. Now, it definitely does not support the impetus behind the 1967 UN protocol. It certainly doesn't support the non-refoulement principle that's embedded in refugee law, which seeks to prevent people from being forced back to a place where they will be persecuted. That's called non-refoulement. We signed and incorporated that principle into our asylum law. Well, there's a lot of problems with that, because what Alito is doing is he's creating a statutory legal line that says if you're outside the line, you don't apply, you can't apply, you don't qualify for asylum. You're inside the line, you qualify. But what this does is it escapes complete moral responsibility for what the United States has done in this entire hemisphere over the last 60, 70 years, where we have entered other countries, pierced their sovereignty, trained military death squads, resulting in deaths in the hundreds of thousands, if not more, in countries from Guatemala, El Salvador, and elsewhere. Our foreign policy has contributed in significant ways to the migration of people coming to the border. So we have a moral role, a negative role, in playing for the movement of these people to our borders. And how ironic that we would create this statutory, legalistic line that says you can't come in, yet we're morally culpable for forcing them to come in the first place. There's a whole list of countries. I can go from Brazil, Argentina, El Salvador, Guatemala, Honduras, Mexico, showing how U.S. foreign policy has led to the killing of hundreds of thousands of people. These statistics, these facts are supported by reputable references in newspapers and journals worldwide. I'm not going to go through that because we don't have time. So we have a moral problem here with the Alito decision. It escapes moral responsibility for what U.S. foreign policy has done and contributed. And when these folks come to our border seeking refuge from the disaster that we helped to propagate, Alito says, well, we control the line here. Statutorily, we can define who we will help and who we won't. What a just a basically weak argument in the face of that moral culpability. So legally, yes, the Supreme Court can decide who can apply for asylum in the United States and those who are outside the United States. But does that support the non-refoulement principle that we legislated into domestic law? It does not. So Alito's decision and the Lado ruling is a complete undermining of the moral responsibility that we inherited and domesticated into domestic legislation in 1980. We've abdicated that role. We undermined the very legislation that we incorporated in 1980, which was the 1967 Refugee Protocol. Why don't we just come out and say, if we don't want to allow people to apply for asylum, period, just say it. Don't play this game about statutory lines that say if you're in, you can apply. If you're out, you can't apply. You can't escape what we have done as a nation to this entire hemisphere. You can't escape the moral culpability of what we've done, and then to use legalistic languages to exclude the very people that we have helped to persecute. Ladies and gentlemen, the U.S. Supreme Court is a fictional body of law. It incorporates fictions to create legal doctrines to include people and exclude people. Don't let the U.S. Supreme Court create a frame where only their legal interpretation attaches to what they may consider their most morally equivalent or morally satisfying decision. It lacks all the moral power that any law could possibly ask for. We'll continue this, ladies and gentlemen. Thank you.